Good morning. Good morning. I'm going to talk about, my name is Emeka Ugwuonye. I think you already know that. But in case this is the first time you're seeing me on Facebook, I'll introduce myself. My name is Emeka Ugwuonye. I am the principal administrator or principal admin for this group, which is called Movement for Peaceful Change. I want to talk about the case of NNAMDI Kanu, which is going to come up in the next few minutes. I think, let me see the time. Okay. All right, let me get it. Yeah. In the next 7 minutes, it will be 9 a.m. at the Federal High Court in Abuja. That's the Court of Justice, the judge hearing the case, Tanko, hearing the case of NNAMDI Kanu, will be sitting in the next 7 minutes, estimated. Because in Nigeria, the court sits by 9 o'clock in the morning. However, sometimes the judge may come in late because the judge is already in her chambers. I can tell you right now. Judge Tanko is already seated in her chambers, waiting for the case, for the court to be set, for her to move in. And usually, in the case of NNAMDI Kanu, there's a lot of activities. In the morning, so much movement, a lot of interest, security people, NNAMDI's legal team, which each time is not up to 10 lawyers. So, and the court is a small place. This particular court is a small space. So a lot of people are coming into this court right now. The security people are at the door, manning the door, not letting everybody come in. And you must understand, because of the court space, because of the smallness of the space of the courtroom, not everybody who wants to go into that court today will be allowed to go in. So normally, the security will be there, keeping people off, keeping those they consider the wrong people off. And as happened in the last case, they kept Bruce Fine out of that court. Bruce Fine was NNAMDI's legal consultant from the United States who came into the court, who came to Nigeria to observe, to monitor the proceedings. Bruce Fine wanted to come into the court, but the security people said he shouldn't come in. That was wrong. I had said it many times. It was wrong to keep away from the courtroom anybody NNAMDI considers important. Whether Bruce Fine was called to the bar in Nigeria, whether Bruce Fine had right of audience before this court, the critical thing was that NNAMDI Kanu considered him important for his defense. And if so, he should be allowed to be in that courtroom. However, failure to allow Bruce Fine in the court was not sufficient reason for NNAMDI Kanu's lawyers to walk out on the judge as they did. Yes, they walked out on the court. Forget all these stories, people trying to change things. Ejiofor walked out on the court. He staged a dramatic walkout, which was foolish and which ended up adding 1 whole month to the period of time that NNAMDI Kanu will be in detention. Because when you walk out of court, what do you tend to achieve? As a lawyer, your client is in detention. You have an opportunity to protest against his detention, to argue for his liberty, to argue for his freedom, and for some emotional, childish reason, you decide to walk out on the court. That means you are screwing up your own client. That was exactly what Ejiofor did. It doesn't matter how you rationalize it. It doesn't matter how you try to spin it. Ejiofor walked out on on the court and left his client to be dragged back into detention. That was absolutely terrible. Ejiofor understood that he made a mistake because he went back. First, he tried to deny what happened. He said no, that he was locked out, which was nonsense. It's not true. He wasn't locked out. He walked out. Then he went back, wrote a letter to the judge, filed an application, apologizing for his rudeness and his unprofessional conduct. And the judge, realizing that this is a big case, it's not about Ejiofor, it's about NNAMDI Kanu and his ideas and his followers and the peace of the country and the justice of the country. Because ultimately, the NNAMDI case is going to be a fantastic test of the quality of Nigerian criminal justice system. So Justice Tanko looked at all these things, balanced it on her usual scale of balancing equities in a court, and decided, hey, I'm going to ignore the nonsense from Ejiofor. I'm going to focus on the real thing, which is NNAMDI Kanu's trial and his right to fair hearing and his right to due process. That's what the court did. So the court brought forward the date. And that is why there's going to be a trial this morning. And you all will be waiting to hear what happens. I am not going to use this speech to delay you before you get to hear what is going on in the court. But listen, one question remains. Today, there are 3 applications pending. One is an application for bail for NNAMDI Kanu. The other is application to determine whether or not the court had jurisdiction to try this case. NNAMDI Kanu's position is that the judge doesn't have jurisdiction because of the manner in which NNAMDI was picked up in Kenya. He was suddenly taken out of Kenya in a manner that is not consistent with the law. Make no mistake about it. Everybody should hear me out. The way Nigerian government took NNAMDI out of Kenya was in violation of law. It was wrong. It was also in violation of NNAMDI's right because they did not go through extradition process. What they did was called rendition. That is, movement of a person, a suspect, in a manner that is inconsistent with the law, by implication in a manner that violates the law. Okay? So, there's no doubt about that. But the big question is this big question. Is that a basis to deny the court jurisdiction? Is the wrongful manner of taking NNAMDI out of Kenya justification to deny the court of Tango jurisdiction? Now, I don't think so. The manner in which the suspect is arrested, the manner in which the suspect is brought to the court in criminal cases is hardly ever a basis for the court, which otherwise has jurisdiction, to decline jurisdiction. This court has jurisdiction. The case of NNAMDI is not new. Jurisdiction over NNAMDI personally, what we call personal jurisdiction, has been vested. He had been vested. The court has a pending criminal case against NNAMDI. According to the position of the court, and validly so, NNAMDI jumped bail. He jumped bail. Forget all this drama. Forget all these stories we like to tell ourselves. Of course, NNAMDI supporters and some Igbo sympathizers of IPOB, they want to say that NNAMDI did not jump bail. He jumped bail. If you understand the meaning of jumping bail, he jumped bail. Okay? So, the court has jurisdiction. The manner in which you brought the accused person to court in criminal cases is irrelevant, mostly irrelevant. There are other ways to deal with wrongful apprehension of a suspect. You can sue for damages, for wrongful arrest. You can sue for a whole lot of things. NNAMDI can sue for Yeah, he could sue for damages. Now, when a suspect has been tortured, as NNAMDI said he was tortured, when a suspect has been maltreated, the court has a way of dealing with it, not by declining jurisdiction. Any evidence obtained by torture could be rejected by the court. Any confession obtained by torture could be rejected by the court. There are many things the court could do to punish the government for the manner in which they arrested NNAMDI. In fact, the court could actually go further and consider every evidence obtained in the course of arresting NNAMDI unlawfully as tainted evidence. And if the evidence is tainted, the court can strike them, can reject them, can throw them out. That may result in the acquittal of NNAMDI. Of course, if you reject all the evidence of the state, that will result in the acquittal of the accused person. But it's a different thing from talking about jurisdiction. When you talk about the jurisdiction, you're saying that the court should just say, hey, I've got nothing to do with this case. You people go away. Can the court do that in this case? No. Why? Because it amounts to NNAMDI just walking away. If this court declines jurisdiction, NNAMDI will just go. But be very careful also. If this court declines jurisdiction and says, okay, no, listen, I don't want to handle this case because of the way you brought him into this court. This man is discharged. If he's discharged, what do you think is going to happen? They say, okay, very well. We got him the wrong way from Kenya, but we can arrest him right in the corridor of this court right now, and that will not be wrongful. Yes. They will arrest him again. After all, in this sort of case, the Nigerian government, the prosecutor in this case, has piles and piles of cases lined up. They can file so many additional charges against NNAMDI. And if you noticed, the government has not filed any charges concerning anything that happened since 2017 when NNAMDI left Nigeria. And that is when the real thing happened. The government has not filed any charges concerning ESN. The government has not filed any charges concerning those people who died since 2017. So, why is the government not filing these charges? They want to know. They want to know whether this court is going to decline jurisdiction because of the way NNAMDI was arrested in Kenya. If you decline jurisdiction and say, hey, but how can the court decline jurisdiction when it already had jurisdiction since 2015? The court already has jurisdiction. It's not going to deny jurisdiction. What the court can do is to reject any evidence that was obtained improperly. So, forget it. All of you. All these lawyers talking about jurisdiction is not going to happen. This court will have jurisdiction because jurisdiction vested long time ago. Because generally in criminal cases, the courts don't care how you brought the suspect to me. Oh yes, the judge doesn't care. The suspect is here. There are charges. There are proof of evidence. I'm going to go forward. All right? So, is there subject matter jurisdiction? Critical issue, subject matter jurisdiction, not personal jurisdiction. Okay? So, bear that in mind, subject matter jurisdiction, we're talking about the substantive act. The acts that were charged in this offense, did they occur in Nigeria? Did they meet the requirement for jurisdiction of Nigerian court over those actions? It's not a question of how you arrested him, whether the suspect walked into the court on his own, or whether you went and grabbed him. The court will have jurisdiction. However, the court may reject evidence obtained improperly. Bear that in mind. But also something you have to understand in NNAMDI's case and in jurisdiction generally is when the denial of jurisdiction, when the declination of jurisdiction, if the court declines jurisdiction, what happens? If it means that the accused person is now going to go free, scot-free, the court is very careful. All these theories about the doctrines and principles of jurisdiction must be interpreted in the context of human common sense. Kenya is not asking to try NNAMDI. Britain is not asking to try NNAMDI. No other country is asking to try NNAMDI. So if Nigerian court declines jurisdiction because of the way it came, that means NNAMDI goes on trial. That means that the issues are no longer important, going to come up. The court is not going to do that. So perish the thought. Okay? Court will have jurisdiction. Go and write it down. The three issues will be bail and where to detain NNAMDI. Yes, the court has a lot of discretion on bail. The court has a lot of discretion on bail. And it's going to depend on the details of the application, what is said in the application, the documents filed in court, the processes, and what is argued in court. Because at some point, a lawyer may stand out there and make a very compelling oral argument in court. I don't think NNAMDI's lawyers will do it. Ejiofor doesn't have the fire. He doesn't understand these things. So he's not going to make a passionate argument. He's going to stutter and stammer, and he's not going to get it. So forget oral argument. Oral argument is not going to be vibrant. It's not going to be bright. It has never been in the case of Nnamdi Kanu because of the quality of lawyers he has, or now the so-called lead counsel he has, who will insist on making the argument in court. He's going to screw it up. However, if they made strong written application, it may carry the day. But will the judge grant bail? Highly unlikely. Why would she? If there is no move from the prosecution, because the prosecution has a very strong involvement in bail. Remember, bail application requires or sometimes involves the opposition of the prosecution. What does the prosecution say in opposition? It's critical. If the opposition says, my lord, we have no objections to bail, we're just interested in ensuring that there is adequate condition, that we have strong terms and conditions to ensure that his availability at the next trial. If he says that, if the prosecution says that they're not objecting to bail, yes, the judge will grant bail. In Nnamdi's case, the judge will not. Why? He jumped bail before. Yeah, I know what you think. You think he didn't jump bail? He jumped bail before. Wake up and think straight. He jumped bail before. The court seized all his passports, believing that seizing his British passport will keep him from leaving Nigeria. Now the court knows no. Also, the judge took 300 million from 100 million from Alariba, one of the shorties, and that did not stop him. So there were strong, stringent conditions, and that did not stop him. So now, assuming that Nnamdi's lawyers come in and say, my lord, we want our client to be placed on house arrest, to be monitored, and the court fashions it. The court may do so. The court has a wide range of power. You have to show the court a new terms and conditions that Nnamdi Kanu can obey. Because the ones they gave him before, he didn't obey them. He left the country. He didn't obey the terms and conditions given them. So you got to convince the court that he will obey the next one. I don't see how that happens. So this court is going to decline bail for now. Of course, bail can be revisited down the line, and there are other grounds for bail. For instance, they can come up on health ground, and maybe there is health ground now. The court can always reevaluate bail application. So eventually, Nnamdi Kanu will be granted bail if he remains there for a long time. But it's not now. It's not going to happen. I've asked myself whether the political discussions would have been sufficient to get the prosecution not to oppose bail. No. The discussions of amnesty, any discussions on amnesty is still at its infancy. They're just beginning to broach the idea. They went to meet the president, and the president said, this is a heavy request, but I promise to consider it. Promising to consider something doesn't mean, it's not a promise to grant the request. It's a promise to think about it, to weigh the options, to give it full attention and then make a determination. That determination is not there. So you don't know what the president thinks about NNAMDI's request for bail. For the Ohanaeze's request for amnesty and what they call unconditional release. And by the way, don't ever listen to that. There cannot be unconditional release. Unconditional release means, okay, go home, continue your life, do as you like, it's up to you. No way. There must be a condition, and the key condition you can expect is he's not going to be allowed to talk about Biafra anymore. He's going to be asked to disband IPOB. He's going to be asked to publicly tell his people that he was wrong, that Biafra is not viable, that they should forget it. You know what that means? Now, and that's where we see the man in NNAMDI. If he wants to be a Mandela, he should reject terms and conditions and insist on Biafra. Do you understand? If he wants to be a man of history, Mandela severally was offered an opportunity of early release from prison, but Mandela said no. He will not agree to be released on the conditions the white people were giving him in South Africa. That kept Mandela in prison for a longer time. Oh yes, his release had always been discussed. He was offered the opportunity of living South Africa, but Mandela refused. So now, will NNAMDI do that? Will NNAMDI say, Mr. President, thank you. I will accept no conditions. I will never give up on Biafra. I will die fighting for Biafra. Will NNAMDI say so? I don't think so. I don't think so. So the comparison between NNAMDI and Mandela is ignorance at best. Otherwise, I could say stupidity. But let's just say it's ignorance. Okay? So, ladies and gentlemen, I've told you my opinion on what's happening in court today. On the issue of where to detain NNAMDI, the court is not going to detain him in prison. There are reasons why not to do so. Prison is too relaxed. The prison authority will not be able to monitor NNAMDI. It is tremendous pressure. They will not be able to monitor NNAMDI. He could still stay in prison. From prison, he will have access. If you put NNAMDI in prison, any IPOB member can come and visit him anytime. If you put NNAMDI in prison, he will get access to telephone. He will talk to his followers. He can actually run Radio Biafra from the prison. So I don't think he will be sent to the prison at all. That's why I told you that those 3 applications will not work. Even though the issue of the jurisdiction will not be decided right now, the judge is going to defer it. He wants to know more. You can understand. A court wants to know more. There are what we call jurisdictional predicates. Those factual events and elements that touch on jurisdiction. Usually those facts don't come in at the very beginning. And that's why a court may say, hold on, let's wait and see. In other words, he was abducted, as you said, from Kenya. Let us wait and hear evidence and see how that might have affected the substantive issue. So jurisdictional issue will be delayed, but then it will be rejected. The other 2 issues will be rejected either today or very soon. I think the judge is going to schedule another another date in 2 weeks' time or less. Bring all the parties back to court and then deny bail or impose bail on conditions that are impossible. Oh yes, what if the judge says, all right, I want to grant bail, but let every member of Ohanaeze come and sign that if NNAMDI runs out, they will be arrested and go to prison. Can you imagine? Yeah, the court can say, fine, bail granted, but wait for you to hear my terms and conditions. Term number 1, every Ohanaeze person should come and sign that if NNAMDI escapes, we arrest them. Every archbishop in the East, come and sign. All those people, Obi of Onisha, come and sign. All traditional rulers come and sign. That That means that if Nnamdi runs, we grab all these Ohanese people and all the traditional rulers in Igbo land and all the archbishops, put them all in prison. The court may ask for that. The court may ask, okay, all those senators from the East that are asking for his constitutional release, come and sign. He filed you back, come and sign. And what I made, come and sign. All of you are going to prison if Nnamdi escapes. What if the court does that? So bail will come, but you got to understand how these issues play out. Okay, thank you very much for listening. I don't want to take up your time. I know you all got to rush and hear what's going on in court today. In the Nnamdi Kanu'S case, as I said, the time is almost 9 o'clock or past 9 o'clock. The time is 9:17. The courtroom of